Business. So we're on to our final panel of the day on contracts and torts. And just to provide a very little bit of framing, because I'm anxious to jump right in, a lot of the focus today has been on whether we can turn to private law when public law can't do the work that ideally it would do. But what's interesting about this panel is that at least some of the papers turn that question on its head and ask to what extent public law or regulation should be allowed or should even try to improve private markets or private law solutions, which obviously we rely on so heavily in health law. There's a lot of really great interplay between these papers, so let's jump right into it. Our first speaker is going to be Craig Knott. Martha, yes, you are the first speaker, yes, okay. Martha Leuven-Karsh and Bruce A. Karsh, Bicentennial Professor of Law at the University of Virginia School of Law, and I will let him take it away.
Thank you so much, everyone. And first, apologies, I'm not in my customary attire. I've been traveling for a long time and then didn't have the time to go back home to get my clothes. The second is that my overall approach to the concept of private versus public law is that I'm of the school that doesn't necessarily believe that the distinction does any functional work, and it's more of a rhetorical frame. And my paper really takes that attitude. And my paper really thinks about the ways in which we can frame certain arguments as private law arguments in order to advance certain positions. So the paper focuses on three kinds of transparency regulations, APCDs, pharmacy benefit managers, and medical billing transparency regulation. And they're all under threat from ERISA preemption challenges. And it's a very modest intervention. It suggests that making the argument that transparency legislation supports freedom of consumer choice rather than simply advancing the regulatory goals of the state, we have a better chance of keeping transparency legislation alive. And the talk does presume knowledge of ERISA preemption. If you don't know, if you need to learn more about it, Liz is happy to talk to you about it. APCDs, PBMs, and all willing provider laws. So basically, in a series of challenges, ERISA challenges, APCD laws were struck down with respect to self-funded insurers in Gobel versus Liberty Mutual in 2015. A couple of years later, in Gerhardt, the Eighth Circuit struck down transparency legislation that applied to pharmacy benefit managers, and I believe that Gerhardt remains good law, though there may be some questions about it. When it comes to surprise medical billing, recent federal legislation may have addressed this question. But really, the question is to what degree and why and how does ERISA preempt the transparency legislation, at least in the case of APCDs and PBMs. The cases themselves, Gobel and Gerhardt, purport to rely on formalistic analysis, and scholars treat Gobel in particular as a straightforward example of ERISA preemption. But courts and scholars have noted that ERISA doctrinal analysis is indeterminate and heavily incorporates policy considerations such as uniformity of administration, burdens on administrators, and the like. Now, one policy thread that has received no attention is that concerning freedom of contract, which appears prominently in these cases. So I argue elsewhere that there is more to Gobel than meets the eye. The employer, in its briefing, suggested that a key problem with ERISA was that it displaced the contracts between plans, insurance companies, and beneficiaries. The laws, quote, interfere with the plan's relationships with its members because the documents governing the plan obligated to keep many medical records strictly confidential, and in other words, safe from state reporting. Second, the laws interfered with, quote, the plan's agreement with the insurance company that also requires that its members' medical information be used solely for the purposes of plan administration. Now, you might think, okay, this is just the employer saying, oh, we like our contracts. But what's weird is that even before the employer filed its bottom side brief, the U.S. Solicitor General's office filed a brief anticipating the argument, talking about these kinds of freedom of contract argument, but in this case, trying to repudiate them. Now, this seems kind of puzzling because state law governs contract terms. And ERISA preemption as a formal matter doesn't turn on freedom of contract or whether contracts themselves are undermined. So to understand the emphasis on the argument, we must turn to the history of ERISA arguments in freedom of contract. Ever since ERISA was passed in 1974, freedom of contract ideas have been part of the backdrop. Courts immediately emphasized that freedom of contract had been eliminated with respect to the pension system. And this reflected the 1970s zeitgeist against freedom of contract. But when health preemption arguments began to appear in the Reagan years, numerous courts framed ERISA as an attempt to maintain the freedom of contract in health contexts. They paired freedom of contract with more traditional formalistic ERISA concerns that the paper goes into in detail. That backdrop helps to explain the arguments in the data transparency cases. ERISA preemption is indeterminate, and courts rely on policy considerations. Some are explicit, such as uniformity of administration, but freedom of contract appears to play a policy role. Gobel and Gerhardt do not make freedom of contract the centerpiece of their holdings, notwithstanding the arguments made in the briefs, but their opinions make a nod to the importance of contractual promises. The Gobel court begins its application of ERISA doctrine to the plan at issue by observing that, quote, ERISA does not guarantee substantive benefits. The statute instead seeks to make the benefits promised by an employer more secure. Similarly, the offense at issue in Gerhardt is described as, quote, dictating the manner by which PBMs contract with pharmacies regarding pricing. In exploring the career of freedom of contract arguments in preemption cases, I turn next to a line of ERISA cases challenging any willing provider statutes. AWP statutes led to some of the earliest ERISA preemption litigation with conflicting outcomes. Over the course of several cases, two circuits held that ERISA preempted those laws. Two circuits held the opposite, and the Supreme Court finally sided with the AWP laws in Kentucky Association of Health Plans versus Miller. Now, the circuit split arose allegedly over the question of whether AWP laws regulated the business of insurance, which, as most, if not all of you know, would mean that they fell under an ERISA exception to preemption. But even the Supreme Court admitted that the insurance savings clause analysis was somewhat indeterminate. And again, I argue in the chapter that policy considerations played a role, prominently freedom of contract type concerns. As in ERISA preemption cases in general, the cases that mentioned classic freedom of contract do so to invalidate the AWP laws to assert ERISA preemption. But two of the other circuits, and ultimately the Supreme Court, went in the opposite direction. In those cases, freedom of contract wasn't mentioned, but courts emphasized a different concept, freedom of choice. As proponents of the AWP statutes emphasized, those cases resulted in consumers being able to choose providers that they wanted. And I, again, go through the language in those cases in some detail. So the contrast is clear. AWP cases coming down in favor of ERISA preemption raised freedom of contract as one of ERISA's aims, namely the contract between the insured and the insurer. In the AWP context, those coming down against preemption invoked freedom of choice, namely choice, the contract between the insured and the provider. In the paper, I situate the relationship and interplay between freedom of contract and freedom of choice arguments in contract law case law from the 1970s that limited freedom of contract arguments or sought to restrain or render them consistent with the idea of true freedom of choice, of the consumer being able to choose and contract with the provider that they would like to contract with. Those courts argued that freedom of contract is truly vindicated when freedom of choice is respected. Now, it's hard to assess the extent to which freedom of contract arguments play a role in ERISA preemption. But courts have consistently noted that ERISA serves the purpose of validating freedom of contract, including in cases invalidating AWP laws. Given the role that freedom of choice has played in neutralizing while vindicating freedom of contract arguments, my claim is that emphasizing freedom of choice may help save transparency laws from invalidation, as they arguably did in the AWP cases. Advancing freedom of choice arguments can meet those who value freedom of contract on their own turf. As I note above, APCDs, or rather as I note above in the chapter, APCDs serve dual purposes. First, public purposes, such as serving state regulatory interests such as price setting, etc. And second, private purposes, such as providing data transparency to allow consumers and other stakeholders to negotiate with insurers. This is true of transparency initiatives, including PBMs and others. But if you look at the briefs, state litigants have tended to emphasize the regulatory, the public goals of the laws, and the paper takes a deep dive into the brief of the various cases where the states, instead of emphasizing the private purposes that the transparency laws serve, end up emphasizing the public purposes. So I ultimately conclude by suggesting that we could learn from the AWP context and emphasize the private choice-supporting goals that the transparency laws serve. A couple of questions to conclude. So should we be using freedom of choice arguments more generally? So for example, if you go back to some of the mainstay cases in, let's say, the ACA context, or NFIB, for example, there you very much see the choice as being between state regulatory goals versus the freedom of contract, the ability of a consumer to choose whether or not to enter a market. So you could talk about the market supporting goals of the ACA. Should that have been done more in that case? Would that have made a difference? The second is the same dilemma that Thomas raised in his presentation, which is by focusing on these market-based arguments instead of regulatory arguments, are we simply reinforcing and reifying the neoliberal approach that emphasizes the importance of private intervention and diminishes the role that the state plays in producing both public and private good? Thank you.
Okay, while folks are thinking of their questions, let me just start us off with one, which is, I don't know if this was the intention, but I sort of read this as a defense of transparency laws, like how can we make sure that they don't get preempted by ERISA?
Oh, it absolutely is.
Yeah. So I guess the question is though, like, why? Like, how do we know that that transparency laws are helpful and worthy of being saved? Like, what's good about them?
That's a fantastic question. I generally, so I think the data is, all over the place, and I know you've written about it. I rely very heavily on the paper that Erin wrote with Jamie, right? For the purposes of this chapter, I simply take it as a premise that that it is a good thing for transparency laws to exist, right? I think that the data is unclear. I don't think it comes down in one way or the other. My own I think antecedents would simply say that when private companies come along, and I think that I am a public law person, right? And I think that I am simply trying to advance public law goals in private law clothes, if that helps. So there we are.
Fair enough. Okay, let's start with Erin.
So a couple things. One, I think that the value of ABCD transparency specifically, it's not necessarily for consumer price transparency, which is limited efficacy at containing costs or anything else, although it's not a bad thing, it's just not necessarily effective. But it's absolutely critical for regulators and for policymakers, right, and researchers. Yeah. Like, we can't do research if we're missing a third of the data out of the state ABCD for no reason other than ERISA preemption. So I think that because there are ways that the self-funded data systematically differs from the rest of the market. So I think there are definitely some reasons to sort of lament the loss of that data from ABCDs. The second comment, or the question, is, you said like you were not really sure whether or not Gerhardt is still the law. I think Rutledge overturns Gerhardt. Okay, yes, I'm looking at the list. I'm like, I think Rutledge, it basically, so Gerhardt said PBM price transparency makes reference, it's the Voldemort rule. You said ERISA self-funded plans, so therefore you're preempted. You lose, go home. And the Supreme Court says, no, that's not what it means to make reference to an ERISA plan. You have to exclusively act upon, you have to single out ERISA plans in some way. And so I think PBM transparency is okay after Rutledge, even though APCD transparency is still off limits because of the weird way that the Gobet court interpreted what it means for ERISA to require data reporting under the federal statute, which is like completely different data. But they're like, well, data reporting, so therefore, you're like interfering with the core central matter of my administration.
No, absolutely. So in reverse order,
So Rutledge at the Eighth Circuit simply says reference to because of the exception to ERISA plans, and the Supreme Court says, yeah, that's not what reference to means, right? But Gerhardt bases its holding on both on reference to and in connection with. And you know, I actually think that Gerhardt's holding on the in connection with prong quite fairly tracks go bail. And the court doesn't discuss the in connection with aspect of Gerhardt. And so I think that the in connection with aspect still remains good law under my reading, and I actually think that as long as go bail is good law, then that part of Gerhardt does survive.
But we haven't heard from Liz yet.
Oh, we haven't, and honestly, you know, that's the problem when there are so many experts in the room, right? It's just sort of like go on the table. But yeah, I mean, the issue of when you first asked me, right, is it why are transparency laws good? I was sort of trying to think, yeah, do I really believe that it affects consumer decisions? And that's why I began stuttering and stammering, because I don't, right? And then finally, I just admitted, right, it's the public benefits, right, that I'm trying to advance under in the private law clothing. Yeah, exactly.
Okay, I'm working my way around. So I've got Bill, Liz, and I'll come back to Chris. Sorry, okay, and also David. Yeah, so go ahead, Bill.
Okay, hi Craig. So I like the resurrection of freedom of choice if you do it very, very carefully as you go. Two things that I think are relevant here to the ERISA analysis. One is not specific to ERISA, but is specific to information-based regulation. Reporting and disclosure are in the digital age often hand in hand, but they are actually somewhat distinct concepts. And the notion of mandated reporting by state law despite ERISA would be somewhat different from various forms of mandated disclosure. And there's good reasons we finesse it, but I think it's worth distinguishing those as you write. The related point, which for me is really the bottom line on Gobet and Rutledge, is insofar as reviewing courts can see the requirement as being a requirement on the employer, purchaser / sponsor of care, they're more likely to find preemption. Insofar as the courts can see the requirement as being on a seller, provider, supplier of care, they're less likely to find preemption. I said this in passing in my own presentation. In Rutledge, I think it's an accurate depiction of PBMs to say they're part of the supply chain for drugs rather than part of the purchasing function, which argues against preemption. So I think it's important to keep that distinction in mind as well. Do these look more like buyers, sponsors? Do these look more like sellers, suppliers?
So, I think, should we just take the other questions?
Yeah, okay, let's take the other question just so we can get everybody and Liz. ERISA fees, I'm here for it. I'm here for all the ERISA today. Thank you for not putting it in the conference title. So that we can like get all these people here and then talk about ERISA. And I'm really interested in kind of a refreshed philosophical take on ERISA. So I guess I have two things that this brought up for me. Number one, on the freedom of contract versus freedom of choice point. ERISA preemption is just for state regulation. So there's nothing inherent about ERISA that says the federal government, right, can't interfere all day, every day. ERISA does not have those limitations in it. So I'd like a little more in the next version about the boundaries between what ERISA does on the freedom of contract and freedom of choice versus the federal possibility. And then number two, I'd like to hear a little bit more about Rutledge and the suggestion in the opinion, as well as in concurrence, that ERISA is really preempting this kind of compliance double up. And so if there's a regulatory vacuum, if ERISA itself at the federal level does not require something, then it's less preemptible, particularly when we're talking about third-party contractors and presumably data transparency as well. But if ERISA does already say something, that's where Rutledge says this is where the fight is. So we can quickly get in, David, and then Chris.
Just a quick remark. Anything that makes people better off
is a public objective. And I thought when I skimmed through your paper, this trade-off that or this little game you're playing, or get the public objective accomplished by making it look private. No, it's all one piece. Anything that makes society better off is a public objective. If transparency and choice does it, you're home free.
I was just going to ask about the thing you started with, which was your clothing. The unconscionability doctrine, to get out of the ERISA space for a second, you highlight the Kugler case from back in the 70s. And as you know, the unconscionability doctrine has two horns, in substantive and procedural. And as I understand, I don't study or teach contracts, the substantive has largely died, but to the extent this unconscionability has survived at all, it's on the procedural horn, which I think actually reinforces your point, maybe to go further, that it's really about the choice, to the extent unconscionability has any vitality at all.
And with that,
Okay, so next up is going to be Christine Monahan, Assistant Professor for the Center on Health Insurance Reforms at Georgetown University's McCourt School of Public Policy, and she is here presenting on behalf of her two co-authors. Is it Manasa Kona?
Manasa Kona.
Manasa Kona.
Manasa Kona.
Good, and Madeline O'Brien. So I'll let her take it away.
Great. Thank you. And just a little quick background kind of caveat about our center. We really study what states and the federal government are doing in terms of regulating private health insurance. We're very public law focused, but nonetheless in our studies, we keep coming up with examples where states are engaging in the commercial healthcare marketplace in this kind of quasi-private capacity. And so for this book, we wanted to contribute and explore some of those efforts a little bit more closely. And so the motivation here for a lot of these states and our real focus is efforts to contain healthcare costs and the negative effects that kind of the increasing healthcare costs are having on patients or consumers as well as employers. And as everyone I think knows here, the primary driver of these costs is increasing commercial prices, namely from hospitals, but also pharmaceutical and medical devices. And there's, sadly, as we've also discussed, little incentive for commercial payers to be negotiating lower prices, and even when they might want to act, market dynamics often favor the healthcare providers in these negotiations. At the same time, regulatory efforts that directly target commercial prices largely have not gotten off the starting blocks due to both industry and ideological opposition to these types of reforms. And so, we're seeing states really consult this very broad menu of options and just trying to do anything really on healthcare costs. And so several of the options that they are considering and some are taking really eschew traditional forms of regulation. And so instead they're seeking to use contracts and their purchasing power to try to drive some form of cost containment. And, one of the first approaches we considered, and that to me is someone who kind of grew up and working in the trenches trying to get the ACA passed and implemented, was this idea of states engaging as purchasers through creating these health insurance marketplaces and being active purchasers. And so these marketplaces are kind of one-stop shops that might be operated by the state, or theoretically the state could kind of create a private entity where you go, you enroll in the kind of health insurance that best meets your needs. And an active purchasing marketplace is one where the marketplace kind of has the authority to kind of cultivate plan choices for consumers and really try to give just the best, highest value options. One complication here, as we'll kind of permeate our paper, is that the active purchasing is this very kind of nebulous concept. Lots of marketplaces or purchasers like to kind of claim or disclaim active purchasing, but what they mean by that can really vary significantly. Some forms of it are really just kind of more like traditional regulation, and it's just we're establishing higher standards than what the federal government or the rest of the state might require, but all plans need to meet them, and if you meet them, you're in. But you do have kind of this, broader view, kind of higher standard of this idea of selective contracting, where the marketplace will actually go and kind of limit, just pick a few insurers to offer plans or negotiate with the insurers who are submitting bids, the terms under which they can join. And pre-ACA, you saw a lot of efforts, public and private efforts to create marketplaces. Most of them floundered until we got, Massachusetts with its health reform law. And then that then became the model for the ACA. And there you saw some real examples of selective contracting, contractual active purchasing for a subset of their market for their subsidized population. Since then, though, even though I think a lot of people kind of, when the ACA was passed, talked a lot about active purchasing, we haven't really seen it take off in this contractual sense. In addition to Massachusetts, really just kind of California as the other primary example where this is happening. And I think, looking at it, there just are a lot of barriers to implementing kind of more contractual approach. Part of it is, while I think some of these more contractual approaches to state action can hold some broader political appeal, and conservatives can kind of get behind them, I think for active purchasing, they're seeing not just that the state is kind of participating in the marketplace, but they're kind of controlling the marketplace, and so that's a little too far. It also, requires a lot of external kind of resources and technical expertise to really be going toe-to-toe and negotiating with insurance companies, and a lot of states don't have that experience, and they're not really equipped to take that on. And then, and this is kind of a theme we keep coming back to, is that, they're entering markets that are themselves already broken and very heavily consolidated. And so, and really this kind of concern about a lack of consumer choice among insurance carriers has just been kind of overwhelming the marketplaces every year since they launched. And just the main emphasis has been how can we get more insurers to join the marketplaces rather than, how can we just like pick the, couple who are best. And so you really only see kind of in a state like California where you might have a dozen insurance carriers in the market and willing to participate in the marketplace where they're able to, exert some leverage here. In most places they can't, and the states really just want to try to preserve what limited choice that there is. So you haven't seen a lot of kind of action to control costs via that mechanism. So then turning to, when states don't have a lot of insurers in their markets, one thing that they turn to is, how can they increase competition? And a couple states here are looking at establishing a public option. Traditionally, a public option is a state-administered, state-funded health insurance plan that competes against traditional private plans in the commercial market. And by state-funded, I mean that the state is taking on the financial risk of paying claims, even though they may collect premiums as well. Now, this it has yet to happen anywhere, this traditional public option. Politics, resource constraints all get in the way, but we have seen a few states take on this more market-oriented approach to creating public option plans. And here, effectively, the state is partnering with private insurers to offer a new plan in the commercial market that advances certain state goals like cost containment. The key issue these states face is when your goal is cost containment, how do you get private insurers and private healthcare providers to play ball and join? And the most kind of developed version of this model is in Washington state. And here, the state Medicaid agency contracts with private insurers to offer Cascade Select public option plans. And there's no requirement for private insurers to offer these plans. It is totally voluntary. And in their first year, they did have several insurers actually contract with the state to offer the plans. And more recently, they actually had they had 7 different carriers submit bids to participate and offer these public option plans. And so the state actually kind of engaged in a selective contracting process just to pick a few that offered the best premiums combined with kind of the broadest geographic coverage. But where they faced a lot of problems has been getting providers to participate. And Washington really stumbled at the start there where they left provider participation like wholly voluntary, while capping how much they could be paid in total by these types of plans. And so most providers opted out, and that really limited how widely these plans could be available in that first year or two. And so there were several carriers, but they still just covered limited zip codes because they couldn't develop their networks. And so Washington came back and revised their law and actually added this, not quite a mandate that providers participate, but effectively gave providers a choice. You participate in a public option plan, or you cannot participate in our state Medicaid program or in our state employee health plans. And effectively, this was predicted to have the same effect as a mandate, but nonetheless, it was framed as still this kind of like voluntary measure. And it has helped, and it has like enabled now the plans to get much broader networks and to expand into other counties. And so, I think one of the challenges the state will face going forward is how do they expand enrollment while maintaining this kind of goal of cost containment? One of the ways these plans keep their premiums down has just been having relatively narrow networks compared to commercial plans, but these aren't going to be the preferred option for consumers. And so how do you get a plan that can attract a broad number of consumers while keeping costs down and keeping provider participation relatively voluntary is going to be a struggle for them. And then quickly just want to talk about state employee health plans. So this is like really the traditional and like the big area where all states have them. They cover a huge number of people. And the states have this great, real vested interest. They are paying for these costs, and so they have much more interest in keeping their costs down. And we have seen several examples of state employee health plans really trying to rein in their healthcare spending, specifically around commercial prices. In 2016, the Montana state employee health plans, they set a ceiling on what they would pay for hospital services at 234% Medicare rates, which shows you how absurd commercial prices are. And this saved the state about $47.8 million over 3 years. Other states have kind of tried to use their vendor procurement process, hiring a TPA or PBM, to hold their vendors accountable for cost containment goals. One strategy is this kind of reverse auction program where you share information about your bids with all the competing vendors and to then try to get them to make better bids in the next round. But still, the states are having problems. There is still not taking off as widely as you might hope. Some of the state employee health plans are constrained in what they can do by state legislatures who face political pressure from the state's dominant hospitals and insurers. And again, the state employee health plans have the same broken markets that they're trying to face, and so they have internal and public pressure to keep the dominant health system as kind of their TPA for their network, to continue offering that Blue Cross Blue Shield card to their plan or whatever the popular insurer is in their state. Same to keep the dominant healthcare hospital in their networks. And it also just takes time, energy, resources, which a lot of state agencies don't have. And so, just to sum things up real briefly, I think it comes down to what can these states do when the markets are already broken and where there is so much political pressure on states to prioritize maintaining consumer choice, which I think they just feel and just pushes them, even though so much of the research shows consumers are not good about making educated choices, even when they have information. So I think it's just a real dilemma. Stop.
Great. Questions? And I will start this direction first this time, if there's anybody on this side. Okay, let's start with Carmel.
So your paper is focusing on the states, which I think is really interesting, but I was wondering if you are interested in bringing in anything around Medicare Part D negotiations, especially with Merck having filed a lawsuit that basically they kind of went through the Bill of Rights. We're okay, let's do the First and Fifth Amendment to argue against being forced to enter into what looks like a private negotiation with a government entity.
That is fascinating. I know nothing about Medicare Part D. Admittedly, our center's focus is surely on the commercial private health insurance market, but that is a good flag, and I will give that a little bit of thought.
Okay, Craig, and then it'll be Aaron.
So I was fascinated. Oh, actually, I don't need this because I'm just asking a question. So I'm just fascinated by the.
It'll still pick it up better for the videos.
Okay. So I'm fascinated by the by your term market-based public option, right? And I think that this might, so what you're doing is sort of, going back to what David was talking about earlier, and my skepticism of the premise of the public-private divide. Right, because I think public and private can only be understood in relativistic terms, right? So I have a completely separate paper that targets the idea of a public option and the entire public option literature, and the idea. So think about, for example, insurance marketplaces, right? Are the contracts made on insurance marketplaces, are they private interactions or publicly supported private interactions? Or so I'm kind of curious as to, do you see a distinction? Converted to a question. Do you see a distinction, though? But I am genuinely interested. So when you say market-based public option, right, do you see it as public law? Do you see it as private law? How would you draw this distinction?
Yeah, I think it's really much more of a spectrum than just a clear binary one way or another. And so another version of this is like what Colorado has, where they have what they're calling them public options, but there it's just like they're imposing a requirement on all insurance carriers to offer some new plans that meet heightened standards. So like what we did here to try to like negotiate just for the purposes of the paper was like where are they using kind of like contracting authority rather than just kind of doing this via regulation and like traditional legislation. And so looking at Washington because like, okay, what can they impose through contracting with these private insurers and kind of impose terms that way and limit who joins this. But it is, it's just, we're drawing very fine lines.
Yeah, appreciate it.
Erin.
So Craig's point is really interesting because, you know, in the public option paper that I wrote with Jamie King and Katie Gudikson, we struggle with that exact same, like, is it even a public option? Like, it doesn't really feel like one. And so we had to come up with this like convoluted definition to capture what states are actually doing. And I'm wondering how much of what states are doing, which is different from like the old ACA, you know, rest in peace, public option, which was, you know, the states are trying to do that thing, but they only can do these smaller bore private law things, right? Like so that they're using the rhetoric and sort of the competition and contracting. We're just like increasing competition in the market, but what we're trying to do is improve affordability and access. And it's really regulatory. It's like what we're not doing is rate setting. Oh, but they are doing rate setting. Like that's what even Colorado is doing rate setting, right? It like has its like pocket rate setting in its back pocket when they'll fail to reach the premium savings targets. So it's sort of like it's just rhetoric. I mean, it's not that it isn't rhetoric with a purpose, but it's rhetoric for political expediency, which goes to Craig's point of like, you know, if we call it, you know, private law, is it private law or is it really just public law dressed up as private law?
Yeah, well, I think the closest analog to these state public options is actually the failed multi-state plans under the ACA, where again, it was the government contracting with some plans to try to offer more competition into the markets. But I think too, like I do like I think the power is like the limited political benefit that you get by claiming that this is contractual and like voluntary, because I feel like there's like a reason I have to think I should do some interviews and like find out, but like that the Washington State Legislature framed how they went about this provider requirement not as a mandate, but as, you know, it is like your choice. This is voluntary, and even in like the fiscal note for their bill, it kind of acknowledges this is going to affect everyone in the state.
Liz.
Oh, I love this inversion so much of the state actor having to basically stand in the shoes of all of the private actors that we've been all talking about today. And I'm wondering if you think there's any possibility that this experience, this like repeated experience of state public employee plan negotiations has any potential to help states step up their antitrust enforcement, their other consumer protection tools, the more that they experience the market that lack of enforcement has created.
That's a good question, and I think some of my colleagues at the center are much more expert on the state employee health plans than I am myself. To some extent, my more limited sense just from kind of interviews with state officials is that the state employee health plans are kind of almost in a bubble to some extent, and so I don't get the sense that they're like pushing for kind of these other reforms and kind of flagging for the state, like, you know, we are facing these barriers, you should be doing X, Y, Z. Like external folks, researchers may come in and kind of like make those arguments, but I don't think they're kind of like pushing that so much.
All right, Craig wants round two.
Since this time. So I think it's very interesting, right? Because as you draw the contractual distinction versus the Colorado, right? Because you could also think about it as a penalty, right? So I fine you, I take away your money by not contracting with you, right? So it comes down to the same thing for the companies. There's interesting work on this actually going back to the 80s, like, you know, where in terms of like trying to figure out the distinction between the state as state actor and state action versus market participant, right? And so the piece I mentioned that working on is basically argues that the way to think about this is, you know, the state often engages in what I refer to as concentric regulation. So at the core, the state provides the services the most itself, right? Either through a public option, it's all relative, right? And then at the periphery, it helps, it supports markets. And on the outside, you have private interactions, maybe relatively unregulated, but this all falls within a public space, right? But I do like this idea of a spectrum, and I do wonder, do you think that that distinction between, like, you could bring in Colorado, maybe, I don't know, sorry.
Yeah, no, and well, just to that end, I think like the next version of it, and I think what distinguishes traditional kind of public option conceptions is just like who is really bearing the risk.
Okay.
And I feel like, and that's where I think like, because even with the traditional state public option model, you can hire administrative third parties to be doing a whole lot of the work.
Yeah.
But to me, kind of like what the kind of universal feature is that the state is the one that if, we don't collect enough premiums, we are the one who's going to need to pay that. But it is so many circles.
All right, we're close to the end. Any last words on the topic?
I'm good, thank you.
So much I want to ask you about ACA versus price setting and all this, but we'll leave that for another time. Good job. All right, we're going to transition now from contract to torch, as I reset this. And let me introduce Mark Hall, Professor of Law and Public Health at Wake Forest University. Take it away, Mark.
Thanks, Sal. So you don't have to debate, is my topic private law? It's private law, okay, private law. And so I've had the opportunity here, as I near the end of my career, to sort of step back and size up a whole block of what used to be part of health law. I'm not sure it is anymore. It's the various parts of health law drift in and out, but for the moment it is. Which is sort of classic medical liability stuff. And it is foundational in the sense that it gets to what is the doctor-patient relationship and what are the special duties and obligations, whether you call them fiduciary or not. So I think it's a good sort of cross-cutting topic that really touches on a lot of themes, even ERISA preemption, as we know. So it gives me also a chance to see if I'm willing to put my, I suppose, mouth where my money is, in the sense that I have staked out a position that what makes health law special and interesting is a study of the way in which law responds to the distinctive features of the healthcare enterprise, that being professionals treating patients who are ill in the context of all these complex institutions and financing mechanisms. And that's what makes it more than what Frank Easterbrook famously said at I think a Harvard conference about cyber law, that it's just, cyber law is a law of the horse. So is health law just a law of, what doctors and hospitals happen to do, nothing more than, law of the horse as an imagined field? And so I've said, well, no, it's more than that, because there are these distinctive features that, similar to the way in which family law is different than, other areas of private law, because the attributes of families and their relationships are so distinctive that it causes us to rework these fundamental doctrinal elements. And health law, not to quite that same extent, but considerably more than the law of the horse, has some of those same features. And so I was given the drafting pen for the first ever restatement of medical malpractice law as part of the restatement third of torts, but restatement first and second didn't have med mal. So this is a chance to, and it's of course all up to the Institute, and I've got two co-reporters, but I'm the principal draftsman, I guess. And so in terms of not just how the black letter's framed, but the principal topics for comments, and then I have more or less complete control over the reporter's notes, and so it's been a very engaging and interesting and fun exercise to see where can I sort of reflect in this drafting, which after all is a restatement, and is grounded in what is the law and what a court's doing. So it's not a law reform institution, but in terms of highlighting aspects of the common law as it exists and as it is evolving, features that really reflect what we consider to be the important elements of I suppose, medical, I hate to use the word enterprise, but what we constitute of, the delivery and payment for health care. And so this is a first chance I've had to step back from the work that I've been doing and then to reflect on the work. And so this is essentially an evaluation of the work that I've been doing, and I give myself, I guess, a B+. So that's the, the end of the story. So to some extent, I've been able to, I think, incorporate some of this view, but to a significant extent not. And the reasons not are essentially the enterprise of the restatement, which is not a law reform undertaking, but also the fact that tort law has both, adaptive elements, as common law can do. It can revisit old principles and say where there are higher order principles or the public policy underpinnings for this has shifted or what have you, and therefore adapt slowly to changes in the world in which we live. But it has other kind of more small c conservative elements in the sense that it's, the inertial aspect of stare decisis, that, well, it's been decided, and therefore we have to stick with that road. And so those tensions, the role of a restatement reporter and the inherent nature of tort law, I think, presented some opportunities, but limited opportunities to sort of highlight this sort of adaptive feature or potential of private law. But the thought that, the benefit of public law is you can try to get it just right, but having done that, it is what it says. So whereas private law, well, anyway, we can debate the larger issues later. But we start with the idea that medical liability law came. I think somebody said, the mid-1800s or something is when all this started. Back when medical healthcare delivery was dyadic. You had a patient and a doctor, and the patient paid out of pocket. And so eventually it became, I guess, a triad when hospitals, healthcare institutions arose, and only a good while later, I guess, what would be quadratic, I guess it would be, where you have health insurance, institutions, doctors, and patients. Now, of course, it's, I don't know, multiverse comes to mind. All possible relationships exist simultaneously, and so we could do one of those multiverse, versions of things. And so given that complexity, how's it captured in classic tort laws as restated by yours truly? I don't mean to be, I'm the restater, but in other words, as drafted. But so the first is that it has some pretty hyper sort of traditional elements in that it's still stated in terms of the classic single doctor treating single patient. And so some of the comments are explicit about the fact this dyadic aspect remains with us. And you can see it, well, the chapter mentions a number of examples, but I'll just mention a couple. The first is sort of at a small bore level of when does the treatment relationship begin and when does it end and what's its scope. The second is a larger scale. What is the liability exposure of a hospital or other healthcare managed care institution? And so in both of those, you see sort of this sort of classic compartmentalization of individual roles and what have you, but you also see a bit more sort of elements of fluidity. And so what I've done is try to highlight where there's this sort of rigid formality, but where's this sort of adaptive quality. And what I've also highlighted, and what I hope some of my commentary on the work will do, and by the way, this is all tentative in the sense that the drafting's going through stages. The Institute's approved a handful of sections, another handful of sections have been presented for a discussion, another handful of sections have not yet been finished yet. And so I refer to things that are likely to change, and I hope it'll settle down in time to get this published, or at least that I can refer to the public version of the drafting process. But so real quickly, for instance, the formation of the doctor-patient relationship kind of has a very adaptive feature at the initial trigger in the sense that the seeking of treatment is sort of a very light trigger for finding a duty that, in contrast with, let's say, attorney-client representation, where you don't form a lawyer representation until you meet with the client and discuss the objectives and sign a piece of paper that says, here's what we're aimed to do and here's what we're not going to do, and then it starts. But the doctor-patient relationship starts if you just ask the doctor a question and the doctor provides some advice, and then you have to sort of reason into what is the scope of that, but it's highly adaptive. I note that sort of that kind of quick trigger, I guess, might not be consistent with the more consumerist era that we live in the sense that if we expect patients to be able to sort of shop around and look at their options and get second opinions and that sort of thing, maybe the formation stage ought to resemble a little bit more what we're used to with the attorney-client situation. But on the other hand, treatment relationships have traditionally been episodic, just around an acute phase of illness, and so once the illness abates, it's thought that the relationship ceases, even though we think of having an ongoing relationship with my doctor. And we've sort of institutionalized that ongoing nature through the idea of the primary care medical home and other features. And so there's some notes or comments that suggest that more continuous notion of a treatment enterprise or treatment relationship is more appropriate than the more transactional idea that we began with at a time when medicine didn't have those attributes. I'll move quickly ahead to the institutional liability and then invite questions and comments on any of this. One can view the sort of progression of the development of institutional liability as sort of moving towards an end stage of full-scale enterprise liability. Bill, is Bill still here? Anyway, worked with the Clinton administration on floating that idea 20 years ago, and it didn't get any traction then. It was also a focus of the ALI 20, 25 years ago, and didn't get any traction then. So in working on this part of the restatement, I thought, is this now the time to embrace enterprise liability? And was told, no, it's not. But because it's still the case that, you know, as courts address this, they say, well, there are all these different types of relationships that different kinds of doctors have with hospitals and that exist on the medical staff or with regard to the hierarchical nature of medical personnel under the supervision of doctors. And so that sort of overly compartmentalized sense of the limited nature of responsibility and joint enterprise, you know, was noted alongside some opportunities to, I suppose, be more expansive in terms of our sense of how things are viewed. So a couple of things to note quickly, and then I'll turn things over. One is that, well, the doctrine of ostensible agency has been, I'm trying to find the right word, but its elements have been softened such that it's much easier to find ostensible agency than it was a couple of decades ago. And also there's instances of using the notion of non-delegable duties to declare institutional responsibility as a matter of law that are cited in the article. But in general, this area of vicarious liability in particular is one where courts are quite explicit in terms of the public policy dimensions that they want to bring to bear. And so I think the restatement drafting is trying to point courts in a way in which they can perhaps free themselves up from some of the older precedents and say, well, what really makes sense in the modern era, given how all these actors and enterprises interact. So questions, comments?
Questions for Mark? I can start things off while you all are thinking of what I'm sure will be your amazing questions. So I'm going to ask one that's maybe unfair because I know you are serving as a reporter in this role, but I want to push you a little bit on the normative question anyway.
Sure.
So we all in this room know that there's been so much criticism of the medical malpractice system and of medical liability. And you seem to take kind of an optimistic take in this chapter on the ability of the common law to adapt over time. And I'm just wondering, you know, to what extent you think it has the ability to address the criticisms about insufficient compensation or unfairness in the system or inadequate deterrence and all of those sorts of key arguments that we've known been raised for a long time.
No, it doesn't. It does not. No, that would require overt law reform. And so those basic elements, I think, are baked into, you know, the essential core concepts of tort law. So the best I've been able to do is try to plant little, I call them Easter eggs, little things that might become helpful along the way. But So let's say using practice guidelines to define the standard of care. So the article, the chapter doesn't talk about that, but there's been a lot of debate the extent to which we should have more, kind of objective, evidence-based statements of preferred practice approaches that then carry with them liability protection. And so wrote some black letter that was more receptive to that, and so far I've been pleased that it hasn't gotten too much pushback, but that's just, a small step in that direction.
Okay, Craig and then Glenn.
I think Glenn was just a mite ahead of me. So.
Okay, Glenn and then.
I was going to ask about
the reality of the institutional liability piece as opposed to like a theoretical possibility. You probably, because of this work, Mark, you probably read more of the underlying cases than almost anybody else. And I'm curious whether you think that while the doctrine constantly repeats about the availability of theories of institutional liability, that in reality they're pled relatively infrequently, or whether you get the impression that they're both pled and successful kind of in proportion relatively well. What's your kind of overall impression about the liability of this in the real world?
Well, if you're talking about hospital liability, no, it's huge, and in fact, it oftentimes. So, in terms of enterprise liability, can tort law, require the hospital to be responsible? Even if it doesn't, I think in practice, often it happens, and more it becomes essentially a moot point in the sense that as more doctors get employed by hospitals, then there are automatically drawn within the hospital sphere, and then if the physician's independent but you sue both and then you need to settle, oftentimes you end up, the institution becomes the predominant driver of the settlement, particularly so that you can protect the doctor from being named out in terms of reporting to the data bank and that sort of thing. So the particular theories of institutional liability available, I think, have a big impact on how litigation's framed and how it's resolved.
So I just want to pick up. I'm going to bang on the same drum as I did earlier, really a little bit, which is to maybe question whether the entire project is purely private law, right? And I'm going to ask it in this way, right? I mean, and this goes. You were
talking to a European legal academic. I mean, they divide their entire faculty between.
I literally was at a conference just now on European private law, and they pulled me up as a moderator at the last minute, and I think they regretted it. And so basically, so when I teach MedMal, I always teach licensing around the same time, right? Because it seems to me that what happens is that the government says, here is a standard, right? It can be enforced by the government. It can be enforced in some contexts, not in the medical context perhaps, by private attorney general actions perhaps, right? Qui tam actions, private tort, right? And so I think this echoes something that David said earlier. Maybe I'm just trying to hide behind David, but basically I'm sort of wondering whether it's a government set standard with different enforcement mechanisms, right? And so what we're referring to as private law is simply a private enforcement mechanism. And this isn't deep jurisprudence because I don't know it, but I'm sure this has been made a lot in the literature about the distinctions between public and private law. But I'm kind of curious as to how, as we sort of try and tease out that distinctions of this panel, how you sort of see this as being private.
Well, here the standard would be, I guess, the standard of care and what constitutes incompetent or competent care, and that famously is defined by the standards of the profession. So it is that seems much more privatized than putting together a deliberative process to say this is how medicine should be practiced or reimbursed or that sort of thing. So there's a distinct character to it that I think. I don't know what difference it makes, but it does seem to be different than.
So in cases of regulatory capture, it becomes private law.
The private institutions are running the agencies. That's one of the main arguments against regulation is that you turn things over to the foxes and such.
All right, let's take the two final questions in a row. We'll see we've got time for an answer. Barry.
So I'm trying to understand how the restatement works. So, for example, with corporate negligence, which some states have adopted, other states haven't adopted, what's the threshold for testing whether, because Pennsylvania calls this these are non-delegable duties, these 4 duties. Other states, Minnesota perhaps has done about the same, other states are in various places. When does this qualify to meet the test of the restatement?
Right, so there.
Mark, let's get Chris's question too, and you can answer them both if there's time. Go ahead.
I was just going to ask about how much you think the changes in the way healthcare industry is organized, medicine is organized, whether it's physicians becoming employees, core practice method doctrine disappearing, managed care, I mean, the rise of all these changes are or should change the doctrine since the last time these principles were articulated.
They are to some extent, they certainly should.
Substantial extent. So to combine the two questions, so as things are currently drafted, there's this concept of a medical institution that either provides or arranges for care. Arranges for would be different than, but it would be, let's say, managed care organizations or perhaps medical staffing agencies and other sorts of things. So draws a sort of a broad ambit for what might give rise to some type of corporate liability, and then distinguishes between those that provide care and says, well, there the duties are pretty well defined, and adopts the Pennsylvania approach. So in terms of how the restatement works, it's even though not all states have come on board, it says here's a well-regarded set of principles that we think are the right ones, and those are the ones we adopt. So that would be more or less the Pennsylvania approach for hospitals, and by association, nursing homes. But then there's the ability to look and say, well, behind that's this more general principle, which encompasses perhaps other types of institutions, and that might be managed care or staffing agencies or management firms and things like that, for which we don't know what the particulars are yet because they haven't really been that thoroughly litigated. Thank you, ERISA preemption. But but in general, the general tort principles apply there as well, and so it creates a less well-defined arena in which courts have some guidance in how to develop things. And so the next restatement hopefully will be able to do a better job of synthesizing what are the further developing principles under AI, for instance.
I think on that note, we're going to thank you.
I had to say I.
Okay, last but certainly not least, we're going to welcome Professor Jill Horwitz, the David Sanders Professor in Law and Medicine at UCLA Law School. And with apologies to her, I think that perhaps her file in the Dropbox is still listed under her co-author's name. So look, if you're looking for it, maybe listed under Rodriguez. She's presenting on behalf of her 2 co-authors, Dan Rodriguez and Alberto de Diego Carreras. So I will turn it over to you, Jill.
Great, thank you so much. So this paper is a funny contribution to the volume because it examines a failure of private law, and in particular, the failure of private tort law to compensate many victims of the pandemic. I want to put a little asterisk here and say this isn't a condemnation of tort law more generally. In fact, I'm working on another empirical project right now about immunity during COVID and finding really kind of shocking results about the relationship between immunity and staffing patterns, medical treatment, and medical outcomes in nursing homes during the pandemic. So I'm a big fan of private tort law. But it's bad enough that I'm between you and a stretch at the end of the day and now also fun at a wine bar, but I'm gonna ask you to think back to December 2020. So it's easy to remember how worried we were then. We worried about population and individual health, and we worried about national and individual economic suffering. It's a lot harder to remember that many people were worried about what Mitch McConnell predicted at the time, an avalanche of litigation leading to a second pandemic for defendant businesses. So in fact, law firms were gearing up to bring suits. Newspaper were discussing all kinds of negligent behavior, like holding crowded weddings at indoor facilities, businesses not protecting employees. I mean, we really thought this was going to be, the age of tort. Didn't happen. Right? In part, this was because of government action and imposition of tort immunity for businesses, including nursing homes in many states, but also because of the features of tort law and the interaction between tort law and the characteristics of this particular pandemic. So you might think common law tort could grow to accommodate the cases, right? Imagine injuries in the form of death or long-term disability, treatment costs, lost wages, harms to third parties, right? All kinds of conventional tort injuries. Businesses owe duties to employees, customers, patients, others they could have harmed by failing to adopt reasonable standards in interactions with people. Businesses could breach these duties by failing to adopt these precautions. Maybe not following certain rules would make them subject to negligence per se. Both actual and proximate cause could, in theory, be established. An employer knew or should have known an employee was COVID positive and done something about it, and the defendant business might be unable to demonstrate that the customer assumed the risk in some way. In practice, COVID-19 posed roadblocks to every single element of the prima facie case, particularly the establishment of causation. So contact with any person while shopping, filling a car, interacting with a neighbor, visiting outside raised the possibility of exposure and infection. And so how do you meet the causal test? Well, in COVID, you most likely don't. So injured people didn't get compensation. I'm not sure we're arguing, what we're exploring in this chapter is how administrative schemes provide a possible solution to either the problem I just discussed at the beginning, a flood of litigation that could devastate the economy or a particular sector, which might happen next time when we have a pandemic with different characteristics, or the lack of compensation for people who are really in need, and that's what we had in this pandemic. So the chapter suggests that we've used administrative schemes in this way before. And the rest of the chapter, after laying out a little bit of what I just discussed, sets out specific examples of when we've substituted tort law with an administrative scheme to address at least one of these problems. So meeting the needs of potential plaintiffs. In the paper, we talk about the Federal Nuclear Workers' Comp Program, the Oil Pollution Act, but I'm going to briefly discuss the Federal Black Lung Compensation Scheme, not go into details about the others. So Congress passed that scheme because existing schemes were insufficient to help minors with the disease, but also because the minors with the disease were pretty poorly situated to bring claims. The injuries, black lung, is a long-term disease, and it's unpredictable in terms of what kind of respiratory disorder you're going to get, when you're going to get it, right? Like long COVID, you don't know how long it's going to last, or even whether you have it, right? And people might die, become disabled from it, and not even really know. So Congress passed this law to help long-term victims and their families, right? We think that might have provided a nice model for COVID. We go through a similar exercise to illustrate several uses of the administrative scheme to address harms to the industry, the economy, and to society more generally. In this small chapter, we kind of merge those together in a much longer paper that we're thinking about writing. We're going to split those out a bit. But I'm going to just quickly mention two of them. I won't talk in detail about workers' comp and no-fault auto, which are probably more familiar to the audience than these two. So the 9/11 Victims Comp Fund, right, which most of you probably remembered as a victims' compensation fund. In the immediate aftermath of the attacks of 9/11, politicians were certainly worried about the victims and their families, but mainly they were worried about the airline industry, right? There were flight stoppages, decreased demand, and this anticipated flood of litigation that was going to put an end to the airline industry. So there's more detail in the paper and more detailed, a lot more detail in the big paper, but I'll just gesture towards what that detail tells you, which is that the name of the act was the Air Transportation Safety and System Stabilization Act. And we think that during COVID or the next pandemic, when there is a threat to a particular industry, the way there was during the pandemic, that we have a nice model for administrative replacement. And then another example is near and dear to my heart because it was my first academic paper. It was about the neurologically impaired infant programs, no-fault medical malpractice. State programs in Florida and in Virginia that replaced tort law for certain infants were really there in part to help families of those neurologically impaired infants, but mainly to do something for obstetricians. In both states, obstetricians were threatening to walk off the job. And so legislatures in both states kind of just took these cases out of the system, even though they actually weren't terrific cases for plaintiffs, because they wanted to help OBs in certain jurisdictions. We think this might be a good idea to explore for a bunch of reasons. I mean, in part because it would get injured people compensation, and we don't have a lot of good ways for doing that. In part because equity favors these administrative schemes, right? We know with COVID that there were certain populations, poor people of color who were disproportionately affected and were also least likely to have access to a lawyer to bring these claims. An administrative scheme would have gotten more people money more quickly. The relative certainty of an administrative scheme when there's a big crisis like this, and also to help businesses stay open, right? There are lots of good social reasons for wanting businesses to survive. Of course, there are some objections to this, and we just touch on them very briefly. Deterrence, right? Morally centered conceptions of the role of tort. If you have an administrative scheme, you're not, able to say, you bad, defendant have harmed me, and so we lose some of the benefits of that conception of tort law. The need for resources, that's the biggie. Do we tax? Do we have the businesses all pay in? It's one thing to ask Walmart to do that. It's another thing to ask a small business, and we're trying to protect through these administrative schemes to pay in. I'm not going to touch on federalism. But these are some of the big objections, but we think it's worth doing at least this thought experiment. So ultimately, we are not setting out anything like a proposal, right? Instead, we're just trying to suggest that we've used administrative schemes to address the uncompensated injuries that we saw during the pandemic, and we've used these schemes to address the problems that a large number of tort claims raise for the economy, for certain industries, for society more generally, and that we might have seen had the characteristics of COVID been any different.
Great. So you want to get it on this, Mark? Let me start off really fast, and then we'll move to the other ones. 2 quick points or questions, I guess. The first is that the examples that you gave, the 9/11, compensation fund, and then the last example that you gave, both of those were in your description about protecting the airlines or protecting the obstetricians. But in the COVID example, one of the weird things is that we aren't seeing a lot of suits being brought against businesses or successful ones either, right? Are we?
Well, that's kind of the point of the paper. So we started this paper, to be honest, I saw Dan give a talk on it, online in 2020, and I wrote him a little email. I'd never met him before, and said, "Hey, don't you think this is a canonical case for no fault?" And so at that point, we were expecting the flood, and it didn't come. Right? We were wrong. And we had to think about, does this paper have any legs at all? And we were thinking, maybe we should just give it up. But then we sort of realized, well, wait a second, the flip side of not having the suits is what we did see is that there are all these people that were harmed probably by negligent, maybe even grossly negligent behavior, and they get no compensation for it. And so there are a lot of people who, maybe their health insurance took care of it, maybe they got, other kinds of funding, but a lot of people who fell between the cracks. And then some kind of administrative scheme might have helped them. So we're not saying we're going to see both in the same problem, but we're saying this is a solution to the problem we might have had but didn't, right? And a possible solution for the problem we did have.
So in the longer paper, and I'm going to get to the other question, so just very quickly, I would love to see you think more about in what circumstances it's okay to do away with the causation requirements and in what circumstances it isn't, because there's so much harm out there. There's so many people getting injured. So why is this the example where we should basically give people money outside the disability system? But okay, let me go to the questions. Barry, and then, I'm sorry, I'll go to you afterwards.
So, I think one of the problems you're probably going to have to explore is, for example, the Virginia neurological damage in the main program had very few outcomes. I mean, I think the threshold, and that's really, I think Wendy's point to the threshold has to be set. Maybe like workers' comp, it just arises out of it in the course of delivery, something like that. Because the causation is very sticky, and these are failed compensation systems. Not the 9/11 one, but the Virginia one and the Florida one, I think, are not successful. And workers' comp is the progressive model, but it's been eaten away by lots of state reforms, so it's stingier and stingier and stingier, although still no fault rising out of it in the course of employment. So what's the best model, and how do you resist the erosion or the failure to set the threshold at the right level? It seems to be a multitude of problems, which is fine, that's fun.
So I think we need a narrow system because it could be everybody ever injured from COVID. I mean, we really want to say that this is a narrow program for people who don't otherwise have assets to deal with the problem. But we haven't even gotten to considering this, and now you want me to figure out how to stop the erosion of the program. But that's right. It has to be something that works, right? It can't go on forever because workers' comp, for example, raises the problems that you talked about. I mean, we're thinking about this for pandemics.
All right, so it'll be Mark, and then Timothy, and then Glenn, and then Chris. In 5 minutes.
I don't have anything to do.
Nothing. Okay, Timothy.
Going back to you, I've already had a chance. All right. My question is, how would you establish, if someone was injured from COVID-19, that their injury was caused by the parties paying into the fund? So, for example, it was small businesses paying into this fund. I could have gotten COVID from a party at my house. I could have gotten it from being at the Capitol on January 6th. There's a whole range of possibilities. You're contrasting that with the black lung case. If I'm a miner in West Virginia and I have black lung, it's pretty easy to establish the coal mining industry is kind of responsible for that situation. But I think with COVID, it's far less clear. And so it's probably beyond the scope of the paper, but I think there's questions about how you can handle that rhetorically.
Yeah, it's a good question, but I think, we're going to have to draw some lines about what kind of behavior you're engaged in and whether your diagnosis, obviously, for something like this, but it'll have to be reasonably narrow and a reasonable definition of, where you were and what you did.
Glenn.
I was going to ask about timing and credible commitment. So in some ways, I thought the best analogy was actually the vaccine compensation fund because there's something we want you to do, which is, create vaccines. The way we're going to do it is give you this advance promise about this, something we want you to stay open as a Walmart, right?
Yep.
But then I wonder if that's politically difficult to get the pandemic passed now for the future. And then I was also worried at the back end, if you do it too late, whether there's any takings claims, if you make it not a voluntary participation, but actually extinguish the cause of action.
So I did think about that second one. I've not thought about that before. Your intuition about the first is what motivated Dan in this. He wanted businesses to be able to open, right, at a certain point, and that involves some kind of risk. And so I think he would attach certain kinds of requirements for behavior if you're going to benefit from this as a small business.
Chris?
Channel David Rosenberg, or try to, since he didn't put his hand up. Especially in the draft, compensation is really central, and you take deterrence as sort of a counter argument to kind of push to the side. But it seems like in the pandemic setting, in particular, if not generally, social insurance solves most of the compensation problems. If people lose their jobs during a pandemic, let's cover their income loss. If people get sick during a pandemic, let's give them health care. And so shouldn't the deterrence of keeping people from spreading the virus be the primary goal, and then just social welfare be the backstop?
Yeah, except it didn't work, right? There were a lot of people who got nothing and were probably injured because they were forced to go to work under conditions they shouldn't have been. I mean, there probably was a fair bit of bad behavior out there, or at least too risky behavior given what we knew at the time. But in terms of deterrence, I think it's sort of the same answer to Glenn's, that if you participate in this, if you get some kind of benefit from it as a defendant, and then we have the problem of who's the defendant, right, and who's the plaintiff here, you would have to agree to follow some kinds of safety precautions, right? So there's some kind of opting into it.
Okay, any final, oh yeah, go ahead.
I'm just curious if you've thought about kind of the opioid pandemic and subsequent litigation as like to kind of run this through your exercise and kind of like where it might fall, because I see that as, I mean, we have had lawsuits and some of them successful, but like where you have so many people who have been injured and establishing causation is very difficult. At the same time, I think deterrence and frankly punishment are also big motivators in there. And so would this be a good solution for that problem? Or should we maybe be expanding or broadening tort law there to make it easier?
And that's interesting. My first thought on the fly about it is that the defendants are so known there, right? It makes it a little, it's in some way an easier tort case. And so
I guess I push back. I think some of them are very easily known, like Purdue, but then too, like, what about the wholesalers? Like, a lot of it, there's a lot of cross finger pointing on, like, the wholesalers were giving out the drugs and the insurers were okaying the drugs, and the government was kind of allowing this to happen too. And so are there kind of maybe more culpable hands than are being recognized, or at least held accountable?
that is worth thinking about. Thank you.
Any final thoughts, Joe, in less than 1 minute?
Just thank you.
Round of applause. All right, if everybody could hold tight for just a few final minutes, I'm going to invite up Glenn and Susanna to offer some closing remarks.